Hello and welcome to our webinar, New HR Laws in the New Year. So I guess I should add in 4 of these. We will leave the remaining time for all of you to answer any questions. Now, if you want to ask those questions right now, you can just access your dashboard over on the right-hand side. Typically, you just type in your question over there, and we'll hold it and answer those questions at the end of the webinar presentation. And while you're looking at that dashboard, please be sure to download today's presentation in the handout section. Again, if you have any problems with doing that, just email me right now, and I will be happy to do that as soon as I can. And also note that before we get started, the whole webinar is being recorded, and all of the accompanying materials are protected by copyright. The presentation provides general information only and does not constitute legal advice. We recommend that you consult with your own legal counsel to address your specific situation. So let's get started today by welcoming our expert panel. First, we have attorney Marla Merhab Robinson. Marla's with the law firm MRJC, where she's a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. And then, of course, we have our people problem solver, Linda Duffy, president of Ethos Human Capital Solutions. Linda works with the business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. So, Linda, I'm going to turn it over to you so we can get started.
Thanks, Julia. Thanks so much. And welcome, everybody. Happy New Year, although it seems like we've already gotten past saying that since it's the end of the month. Thanks for joining us, though. We have a full slate of things to talk about. About different legislative changes that went into place both at the federal and state level, and then also talk about some case law changes, and then also as we go along talk about sort of how what some of the trends that we're seeing and things to watch for in the coming years. So let's talk about minimum wage increases. Everybody knows this by now, I'm sure, but we are starting to have a split minimum wage level that goes on in the state of California going forward. Probably also know that toward the end of last year, on effective December 1st, we were supposed to have a federal increase in the minimum salary for exempt personnel. That got put on hold by a judge in Texas, and time will tell what happens with that. My best guess is, knowing that Trump's now the new president, that's probably not going to come up anytime soon with the new Department of Labor Secretary, but we'll see what happens. But for right now, the federal law still requires a much lower salary than we have in the state of California. So the state of California, we need to be playing by California rules, which are the higher minimum wage and therefore also the higher minimum salary for exempt personnel. So for the first time, at least that I know of, we have this split where it depends on how many employees you have in your company. That's going to dictate your minimum wage. It will ultimately get caught up, as you can see, by January of 2023. But right now, if you have 25 or fewer employees in your company, you're still at the $10 an hour rate, but if you have 26 or more employees, it's a $10.50 rate. So what is interesting, though, is what happens if you're right on that border. What happens if you have 25, you hire somebody, somebody quits, you go back and forth. The Labor Commissioner has given some guidance that says if at any point in the pay period you hit that 26 employee threshold, you need to compensate your workers at the higher rate for the duration of the pay period and then going forward. 26, and you pay people, as of the 15th and the end of the month. For that first 15-day period, you want to pay them at the higher rate. Let's say you drop back down on the 20th to 25. For that 2-week period or 15-day period, you want to pay them at the higher rate, because for any portion of that time, you're at the 26 level, just compensate everybody at that higher rate. So it will get a little confusing if you're right on that cusp. Hopefully people can go from 24 to 26 and skip over that. Of course, if you're in the city of Los Angeles, you have an entirely different rule. Right now, everybody's at the same. We caught up, state of California caught up with LA effective July 1st. So right now, until July 1st, 2017, we're at $10.50 and $10, just like I stated. But if you have employees working in the city of Los Angeles, then affected and unincorporated areas, as of July 1st of this year, so under 6 months from now, look at the jump there. It's $1.50 an hour, so it's going to be a huge increase for people that have 26 or more employees, going to be at $12. And if you have 25 or fewer, you're going to jump to $10.50 an hour ahead of the state. Okay, so it's important to keep track of this. There are other local ordinances. San Francisco, San Diego, San Jose, everybody's got different rules going on. So make sure you're looking, of course, at your local city or county regulations as well as state and feds, because it's starting to get very complicated. The other thing that's complicated about the Los Angeles minimum wage is the definition of employee. So I'm going to read this to you. It says it's any individual who in any particular week performs at least 2 hours of work within the geographic boundaries of the city of Los Angeles for any employer. Okay, so this employee is covered by the minimum part-time, temporary, or whatever. So this will also get confusing for employers outside. Let's say, for example, we have an employer that does window coverings. They're based in Costa Mesa, but they send employees up to Los Angeles all the time to do different jobs. So if that employee is working in the city of Los Angeles even 2 hours that week, we have to make sure that we are tracking and paying the minimum wage. Thankfully, they make more than that, but paying the minimum wage at the higher rate during that week. To make it even more complicated, LA has its own sick pay policy, which is twice the entitlement that the state of California requires. So we have the added burden, if you have employees working in the city of Los Angeles, that you have to be accruing sick time for them at a higher rate. So we're front-loading 48 hours if you're going to front load, or you can accrue, but 48 hours instead of the 24 hours or 3-day minimum. Okay, so you can also limit the sick pay usage, but to 48 hours instead of 24 hours. So the rest of it's fairly similar in terms of, you know, how the accrual works, using on the 90th day and things like that. But this has actually been in effect since July 1st, 2016. So you want to make sure that if you have employees working in the city of Los Angeles even 2 hours a week, that you're figuring out a way that you can track their additional sick pay benefit compared to what they normally would accrue if it's not at that level. Now, I do know of at least one payroll company that's been set up to do that, so if you need a referral to that, please let me know. But however you're going to do it, whether it's manually or through your payroll company, you need to figure out how to set up separate buckets for the sick pay and the minimum wage. There's a few other LA requirements as well, just to talk about. In the city of LA, of course, that you have to post it in a language spoken by at least 5% of your workforce. So I put a link there. This is a really handy-dandy link. There's also on this page for employers where you can sign up to get notices of any changes. So I would encourage you, if you have employees that are working there full-time, part-time, 2 hours a week, whatever it is, or think you may in the future, just get on their mailing list so you can get those notices. They also say that you should be keeping payroll records for 4 years. Marla and I always recommend 7 years, but you want to make sure you're doing it for a minimum of 4 years. And then the last one is really something that's already covered if you're as I know you are, issuing the wage theft notices, which I'm going to remind you of in a minute anyway. Now, all with the minimum wage increases, remember it has other impacts as well. So the wage theft notice, the Labor Code Section 2810.5 notice that you're required to give all non-exempt employees, remember you're also required to give it anytime any of that information changes. The one caveat is if the only thing that changes is not the company's address or workers' comp carrier or sick pay policy or anything like that, if the only thing that changes is their base rate and it's going to be reflected on the pay stub, which it is already required to be, then you don't have to issue the wage theft notice. But if for some reason it's not going to be reflected properly, you want to make sure you're issuing that to your non-exempt employees. The other change that happens with minimum wage increases is you have the minimum salary for exempt that goes up. So if you have 25 or fewer employees, you're still at the same minimum salary of $41,600. But if you are an employer that has 26 or more employees, then you're at the $43,680. Now, one thing to note about this is even if your minimum wage, like in July, is going to jump to 12, the rule minimum wage for the state goes up. Even though you're paying a higher minimum wage, your exempt people will still play by these rules until next year when they go up again. Remember also to update any posters that reflect minimum wage. And then we're not going to go into this, but just a reminder that if you need help with wage compression issues, meaning, you've had somebody here that's been working for you for a year, and, they're at $10.50 an hour, and now all of a sudden all of your employees are at $10.50 an hour, you have some wage compression issues because they're going to be like, wait a second, I'm showing this guy how to do his job, and now you're telling me you're paying him the same amount. That's going to be a huge burden on Los Angeles employers when the minimum wage jumps to 12, because that $1.50 is going to probably have a lot of people impacted by wage compression. So just remember that issue, take a look at it, and if you need help, let us know. Some other wage and hour changes that have gone into effect. The minimum exempt salary for computer professionals, remember, is different from the regular exempt salary of twice minimum wage. And this is actually 2 times that exempt salary over 2 times. So if you have computer professionals, and again, you want to make sure if you have exempt computer people that they're meeting a very high standard there, but it's $88,000 a year or $42.35 an hour. That is their minimum exempt salary. So a lot of times I'll have clients go, yeah, I'm paying my, help desk person, over the $41,600 number, and I'm like, wow. Okay, totally, you got a problem with that exempt status, number one, probably based on duties, but that's the wrong standard in terms of exempt salary. So make sure your computer professionals, $88,231. Licensed physicians and surgeons has a rate of $77.15 an hour. Again, if you've got private teachers, then reach out to me or Marla and we'll help you with this, but the minimum salary of private teachers has a new salary offered by any school district anywhere in the state, or no less than 70% of the lowest scheduled salary offered by the school district or county in which the private school is located. Hope you guys got that, because that's a little convoluted to me, but we can help you figure out. If you do have private teachers, then reach out to us. We'll help you with that. Hopefully you've already put that in place. A couple of other things about overtime that came into play. Domestic workers had a special overtime rule before, and now for them, they have to be paid overtime after 9 hours in any one day or 45 hours in a work week. So a little bit different from the regular overtime rules, but now they're subject to the same overtime rules as everyone covered by IWC Order 15. And then if you have agricultural workers, AB 1066 actually eliminated the exemption that you've been enjoying, and now you have to pay overtime the same way you pay everybody else in the state, and after 8 hours in a day or 40 hours in a week. So let's look at a few other pay issues. There were a couple of amendments to the California Pay Act that were signed by Governor Brown last year. AB 1676 actually established that you cannot by itself justify a disparity in pay based on the employee's prior salary. Okay, so most applications out there, ask people, okay, how much were you making in your last position? And I know a lot of my clients take a look at that when they're trying to decide how much to offer this person. The rule for this, I think, is pretty straightforward, which is we're trying to eliminate wage discrimination based on gender, which is also already a rule, but a lot of times that discrepancy exists because we continue to perpetuate it by offering somebody what they, based on what they were making before. So you have to have some of the justification for why you're making that offer different from how you're paying other people. Having said that, it's discrimination based on gender. And now SB 1063 added race and ethnicity to that list as well. So you are prohibited from paying an employee at a wage less than rates paid to employees of the opposite sex or a different race or ethnicity in the same company, and it says for equal work on jobs, the performance of which requires equal skill, effort, and responsibility, and which are performed under similar working conditions. So you want to make sure that if you have, you can easily run a list out of a payroll, your payroll system, and if you have a list of people and you have them in the same job category, same job title, and you're paying them differently, you want to make sure when you take a look at that, you can document the reason for the difference, whether it's 10 cents an hour difference, $20 an hour difference, whatever it is. You want to make sure you can say exactly what's making up that differential. One other trend I can tell you about at this level, there was a bill introduced last September, HR 6030. This is a federal Pay Equity for All Act, and one of the things it's going to do is make unlawful for an employer to screen prospective employees based on their previous wages or salary histories, even ask what that is from any prospective employee, or discharge or retaliate against an employee for complaining about this. No action has been taken in Congress toward this since it was introduced last September, and again with the Trump administration, we'll see what happens. I would tend to believe that it's not going to go too far, but just wanted you to understand that what's the trend. One of the trends we're seeing in employment law is the trend is to say, hey, you're not allowed to ask somebody what they used to make. You can't make your decisions based on that. You have to make them based on what is the pay for this position and what are you going to pay someone relative to other people in that role. Another trend we're seeing is around criminal history. Again, difference on the box law. What I find interesting in LA is Los Angeles in this context and not Louisiana. Los Angeles has even a stricter ban the box law that went into effect this year. You cannot ask about criminal history until a conditional offer is made. That means you must remove that question from your application, and you cannot ask about criminal history during an interview process. You have to wait until after a conditional offer is made. You are forbidden under the text of the law from doing any sort of research on your own. This would include social media, presumably, but you cannot go out and go to any free site and look at their criminal history. You cannot run a background check. You cannot do any of that until a conditional offer is made. And then it also has rules that if you decide you want to rescind the offer based on what shows up in the criminal history in the background check, then there's a prescribed steps that you need to follow in order to rescind that. Okay, so that's for Los Angeles. A couple other things. AB 1843 applies to the whole state. That changed the labor code to prohibit employers from considering juvenile criminal history, and it has a very long definition of what that is. So it says anything related to an arrest, detention, process, diversion, supervision, adjudication, or court disposition that occurred while the person was subject to the process and jurisdiction of juvenile court law. So you want to make sure that if your employment application is inquiring about criminal background, you need to modify it to exclude this along with your marijuana convictions and everything else that's already, for most of us, listed there. Finally, there's a background check that went into effect. This is only going to affect you, obviously, as a consumer, but as an employer, if you're a transportation network company. So it's requiring those companies to conduct comprehensive criminal background checks, and they're not allowed to hire any registered sex offenders or people who've been convicted of violent crimes, assault, domestic violence, or DUIs. They're not allowed to drive for companies under the new law. If they do, it's a $5,000 fine. And the definition, just to be clear about this, is the transportation network company connects paying passengers with drivers who provide the transportation on their own non-commercial vehicles. Okay, so all parties also need to connect to the service via website and mobile apps. So it's very specific, really Uber, Lyft, Probably, we were just signing the other day talking about this, probably not even taxi cabs, because that's not usually how people connect, and it's probably not their own vehicles. But anyway, so just know if you are with one of those companies what you need to do. And what's interesting on this also, and we'll see if this becomes a trend, for the background checks on these companies, it's comprehensive. It's not restricted to 7 years as most of them are. There's a posting requirement, a couple posting requirements that have gone into play. Single user restrooms. So this came up last year with all of the transgender, gender identity issues that we've seen. And so going forward, effective March 1st, so you have over a month to be in compliance here, any single user toilet facility has to have a posting on it that is identified as an all-gender restroom. So you will no longer, if it's a single toilet restroom, be able to have a woman's room, a men's room, something like that. It needs to say all-gender restroom. Okay, so if you have obviously multiple stalls, then that's a different issue, but single toilet has to have that posting on it. Second thing is on smoking. This went into effect last year, but I wanted to bring it up because I think a few people missed this. So June 9th of last year, the smoking law in businesses changed. Lobbies and warehouse and even you know, single owner operated businesses, you know, used to be able to have, you know, be able to smoke in your own company if it was just you, or, you know, bars and hotel lobbies, and they took out a lot of those. They also defined e-cigarettes and vaping devices that contain nicotine as smoking, and it also eliminated the exemption for employers with 5 or fewer employees, and finally raised the minimum smoking age from 18 to 21 except for active military personnel. So all of that went into effect. But what you also must do is if you have a building where smoking is prohibited throughout the building, every entrance should have a sign that says no smoking. And if you have certain designated areas of the building, and again, you want to be careful and clear on what the exceptions are to that, but if you have areas of the building where people can smoke, then you have to have a sign stating smoking is prohibited except in designated areas posted every place. So that's something else to just be aware of when you're ordering your signs. We have a requirement for a notice that has to be given out, but it's not due until July 1st, so it's a few months away, but just wanted to make you aware of it. And that is for victims of domestic violence, sexual assault, and stalking. This is most likely already in your handbook, but it's going to specifically require you to give employees a notice on or before July, or effective July 1st, telling them that they have the right to take time off, you know, under that section of the Labor Code, which is 230.1. I think probably what we'll do is just incorporate that language, if it's allowed by the under this law, into our handbooks, so it's a non-issue. But if you have 25 or more employees, you're going to be required to give them that notice. The notice hasn't even been developed yet, so stay tuned for that. But the Labor Commissioner needs to fact. One other handbook provision that you should just take a look how your language is in case you want to reword this. I know our handbooks, when we write them, say basically hands-free only, but it amended, this AB 1785 in California amended the use of wireless devices to say it's okay to use them if you can just activate them or deactivate them with a single swipe or a tap. But the device has to be mounted so as not to hinder the driver's view of the road. So that's pretty specific. So just make sure that if you allow people to use it, that it's mounted as well. One other notice that I just want to touch on, because I think this flies under the radar a lot. California just came out and basically has their own requirement, but it's complying with the federal requirement. There is this thing called the Earned Income Tax Credit Notice that for employees making under a certain amount of money, they may be able to get a tax credit. The level of income, like the high end is like $55,000, it goes down from there, but it's all dependent on whether you are filing single, married, all sorts of things. The rates are different. My personal advice is just send it out to everybody, but you have a requirement to send this out plus or minus 1 week when you send out the W-2s, which of course are due in a few days. So if you've already sent out your W-2s, then send this notice out to everybody. I've provided you a link where you can download a PDF. The other thing to note about this, I'm not sure why they did this, but they specifically say that posting it someplace like on a wall or providing it, posting it like on a shared drive will not comply with the law. It has to be delivered to each employee, either handing it to them directly or mailing it to their last known address. Okay, so sorry about the bad news there, but you want to make sure that you get this notice out to at least those employees that comply, and you can Google that and look at the is hopefully you saw our I-9 webinar that we did last month. Hopefully also everybody knows that January 22nd, just a few days ago, earlier this week, there is a new I-9 form that's in effect. I'll just make this one little pitch, which is the electronic version I think is pretty darn great, and they sort of dummy-proofed it. It's sometimes hard to download from their website. It gives you an Adobe error a lot of the times, so try different methods of downloading to see. There's also a widget you can get that you can download to your desktop that will allow you just to go and click on it and start a new form. There is a paper form as well, so just Google new form I-9. It'll take you to that website, and then you can look at it from there. We did a great webinar on the Form I-9. We also had an immigration attorney on there talking with us as well. You can go out to YouTube, look up our channel, Ethos HCS. I'm sure it's on Marla's channel as well, and you can watch it there, and then just reach out if you have any questions. It's a good time to also remember to go back and audit all of your I-9 forms, because we always, 100% of the time find errors on them when we do an audit. So if you want help with that, let us know. There's also SB 1001 that this is already federal law. It's just saying that state law now, of course, is duplicating the federal law, and it prohibits employers from specifying which documents employees have to bring you for their I-9 form, or requiring more documents than is necessary, or refusing to accept documents that appear legitimate on their face. So how this shows up sometimes is an offer letter goes out that says, hey, on your first day of employment, bring your driver's license and your social security card. Okay, that's in violation of the law. What we usually do is say, bring documents that satisfy ability to work in the United States, your eligibility to work in the United States. Here we've attached a list of documents that comply with that. So that's how we normally say that. But do not tell people, bring me this or this. You can also not require additional documents. Now, sometimes there's a reason to do it. So for example, let's say you're going to be driving for a company and you have a requirement that people have to bring their driver's license because you give that a copy to the insurance company or something like that. That's fine, but just make sure you're making that request for that reason and not saying bring it for your I-9. And then also, if you get a document and on the face it appears to be legitimate, you cannot then turn around and ask to see a different document or additional documents. Okay? So we do have that come up from time to time. I just wanted to make sure everybody's aware of that. There is a $10,000 penalty, among other relief, if you are in violation of this law. So we want to make sure that nobody violates that law. And with that, I'm going to turn it over to Marla.
Thank you so much, Linda, and especially for taking the bulk of this program on. As everyone can see, there's a lot of new laws this year, and often we don't have this as the case, but this year you can see many of them do require a review and a revision of your handbook. So while Linda pointed out a lot of the posting requirements and referenced the handbooks a couple of times, I just want to really emphasize the need to review them and get them revised to comply with these new laws. So the first new, not really new law, but new issue that I'm going to talk about is reporting labor violations. And this is just a result of the world of the state and federal governments catching up with the rest of us technologically. The Department of Industrial Relations launched an online system for reporting labor law violations. Most labor law violations that came in the past to the Department of Industrial Relations came in the form of someone walking into the office necessarily the person who's going in and saying, I want to file a complaint because I didn't get paid overtime, or I want to file a complaint because I didn't get paid minimum wage. This allows for any labor law violations, and it allows the labor commissioner to receive them, obviously in a way that allows them to move on them quickly, prioritize their leads for investigations. Now, many of you may not know that this department has the right to drop in on an employer at any time and conduct investigations and seek information without subpoena power. I mean, it has its own subpoena power, but without going into court separately. And this allows them to have information on where to go, and so that they can issue citations, including civil penalties on wages that may be owed to correct the problems that are reported. So just be aware, and then of course you can find this site on the Labor Commissioner's Office website. The first law that I'm going to talk about is AB 2899, which is posting a bond to challenge a wage claim. Many of you may already know that if you have an employee who goes into the Labor Commissioner and files a wage claim, and you lose that hearing, you don't settle at the settlement stage, and you have a hearing and you lose at the hearing and you want to appeal, you already have to post a bond to have the right to appeal to the Superior Court. This is an additional bond requirement in the event that the Labor Commissioner has issued a citation against an employer, maybe not necessarily from a complaint that arose from a particular employee. It may be, again, from that website, and they've gone in and done an investigation. So it's just clarifying that in that case, too, a bond will be required, and the bond is in favor of any unpaid employee or employees. It will cover the total amount of any minimum wages plus liquidated damages and any overtime compensation. Basically, employer fails to pay the amount owed within 21 days from the conclusion of the challenge or appeal by the employer. The next matter is regarding OSHA, and this is actually all the way back in May of last year, May 2016, when OSHA adopted and accepted some final rules relating not really to drug testing. They were relating to tracking injuries at work. The purpose was to make sure that there's a reasonable procedure for employees to report injuries and to explicitly prohibit, which it's always been the case, but to make sure that everybody stood, there's explicitly prohibit retaliation for reporting an injury. And out of these rules came the discussion regarding drug testing, and OSHA rulemakers made it very clear that they do not want employers to have automatic testing in the event of an injury. The employer needs to have a reasonable basis for believing that drug use by the reporting employee, the employee reporting the injury, could have contributed to the injury or illness. It does not prohibit employers from drug testing employees who report work-related injuries or work-related illnesses. It's just that the employer has to have an objectively reasonable basis for testing, and the rule does not apply to drug testing employees for reasons other than injury reporting. So if you have an employee who comes in and is acting funny and smells of alcohol, or has eyes that are dilated and is slurring their words, and you have other reasons for suspicion drug testing, this rule has nothing to do with that. This rule is again, it was devised to properly track injuries at work and report them and encourage employees with respect to your handbook and what your drug testing policy says, especially if you are currently automatically drug testing in the event of injuries at work. You need to evaluate whether you have a reasonable basis for drug testing an employee when a work-related injury is being reported. And the central inquiry will be whether you had a reasonable basis for believing that drug use had something to contribute to the injury. If there's no basis at all for thinking that drug use had to or contributed in any way to the injury, you would not want to be testing. So the language in your handbooks is really going to need to be very much addressing this reasonableness, which is a difficult standard. So marijuana, everybody's favorite subject. Everyone probably knows that Prop 64 passed back in November, legalizing possession and recreational use of up to 28.5 grams of marijuana and up to 8 grams of concentrated marijuana for adults. And again, adults here is 21 and over, not 18 and over. There's some provisions in the law that also allows for some growing of a certain amount for adults as well. I get calls daily, sometimes several times a day, from employers with respect to this law, because employees are under the impression that because marijuana has now become legal, that they can be under the influence of marijuana at work, and that is just absolutely incorrect. It's no different than alcohol and even prescription drugs. Many of you have handbook policies that state that you cannot be under the influence of prescription drugs. An example is everyone lately has got that cold with that horrible cough and take cough syrup with codeine. If your employer prohibits the use of prescription drugs that can alter your ability for your motor, no different. And that includes those who have the certificate or permission from their doctors to use marijuana even before the law was changed. There's nothing that allows an employee to be under the influence of marijuana at the workplace. Now, the difficulty here is going to be something that the police are dealing with driving under the influence. Marijuana can stay in your system for many, many, many days, even if you are not the person who smoked or ate, or different ways that you can ingest it now. The marijuana, you can test positive for it. You can be in a room with people who are smoking marijuana and test positive for marijuana. So we're going to see a lot of changes here. We're going to see a lot of new laws come out about this. We're going to see, I'm hoping, some new regulations about what is and isn't. For example, with alcohol, you have your limits for driving under the influence. We'll have some identifications there with the marijuana, but I think it will be a long time before we see any cases or statutes that suggest in any way that an employer has to accept an employee who has been smoking marijuana. Now, I will caution you all, because I have had this happen many times, where I have clients who are drug testing applicants, and someone will test positive for marijuana, and the employer will call me and say, well, I still want to hire this person. I really don't care about marijuana smoking, eating. And my response is always, if you don't care as an employer about the use of marijuana, then don't test for it. Don't test for it. You don't need to know whether the person is ingesting marijuana or smoking marijuana or around people who are doing that. Now, if you have safety-sensitive machinery, positions, you should be testing. And so get some assistance on that policy as well, depending on what your company culture is. The next surprise, or just maybe the surprise here, is the delay in which it took for this to get adopted. We had in the past had the ability for employers outside California to put in employment contracts with employees who are located here in California, that the law of their state and the venue of their state would apply. And what venue means is if there's a dispute between the employer and the employee, the dispute would be heard in the courts of the chosen venue. So if you had a New York employer employing a California employee, and even though the California employee was doing all the work in California, performing all the services in California, if there was a dispute, the contract could say, you got to come to New York and sue me, the employer, and by the way, New York law is going to apply, and it's not as friendly, as most states are not, as California law to employees. Well, Labor Code Section 925 prohibits employers from requiring California-based employees to enter into agreements, including arbitration agreements, requiring them to have their claims heard outside California at a non-California forum. If the claims arise in California, if they arise outside California, that's different. It also requires that that the law of California apply to this dispute. So it's important to recognize that there's two issues here with this new law. It's the choice of where the dispute will be heard, and that will have to be California if the services were performed here in California and the claims arise here in California, and which law will apply. You might be an employer who's based in New York, has your principal offices in New York, and 90% of your employees in New York, but if the employee primarily works and resides, and those are the elements that are required, primarily works and resides in California, then California law will apply and the dispute will be heard in California. So where your employees are located, determine whether or not they would qualify under the statute, meaning do they primarily reside and work in California, and if so, review their agreements, see what they currently say, and modify them for after January 1st of this year to reflect the new law. So the next item is not a new law, but case interpretation of existing law, and it's horrible for us employers. I just have written all over my slide, horrible, horrible, horrible decision. And this is the Supreme Court case on Augusta. So I'm going to ask you to just bear with me and give me a little bit of time on this. This case is about security guards that brought suit against their employer, alleging that their employer failed to consistently provide uninterrupted rest periods as required by law. We all know we have to the 10-minute rest period. And the employer acknowledged and agreed that it didn't relieve the guards, the security guards of all duties during rest periods. It required them to keep their radios and pagers on, remain vigilant, and respond when needs arose. Now remember, this is not somebody who is off duty on call. This is somebody who's on duty. This is a rest break, your 10 minutes. And the California Supreme Court held that California law requires the employers to provide the rest periods free from duties and employer control. And that's a statement of the law, but more importantly, that requiring these radios and pagers to remain on and remain vigilant in case they got called was in violation. Very, very difficult. Lots written about this case on the internet if you want to, listen to the employer side scream about it, but it is the law of the land now and something we have to comply with. Now, understand that it doesn't mean that rest breaks can never be interrupted or denied. For that. And of course, if you do interrupt, then you're going to have to pay the employee the 1 hour of pay for the missed break. So this is an area for those of you who have employees that you need to be able to have on call and need to be able to get, even during break periods, you've got some exposure there. We attached in some cases to watch, just a couple. And of course, all of you are on both Linda's and our email blast, I'm sure. So when we get rulings on these cases, we'll get them out to you as soon as we can. The first is Alvarado, and it's a case before the California Supreme Court regarding the proper method of calculating overtime pay. And this is when the employer receives both an hourly wage and a flat sum bonus. I know we've always followed the Division of Labor Standards Enforcement method, but this was an employer who followed a federal method. So much like everything else that's going on in our world right now, we've got the federal versus state issue, and we'll get a ruling here in a determination. The Dynamex case is a wage and hour class action involving claims that the plaintiffs were misclassified as independent contractors. They're looking to be certified based on the Industrial Wage Order Commission definition versus the right to control test, the common law test. So we'll hear from the court on that. That's always of issue to everyone because we have so many workers that are misclassified, and the penalties are huge. The Mendoza case is really looking to the court for some direction on what's a day of rest in 7. How do we calculate the 7th day? Is it by week? Is it consecutive? Is it rolling? So we're really just looking for some direction from the court on that. And it's Nordstrom. So the next one's also another large employer, Troster versus Starbucks. And this case is to be decided on whether the Fair Labor Standards Act de minimis doctrine applies. This is an employee who is claiming wages for time he spent on closing duties after he clocked out. And the employer is claiming, well, they were just, it was just de minimis time. We've had some cases on that in the past, and that usually seems to go on how much is the de minimis time. 10 minutes, 5 minutes, 3 minutes, but we'll see. And the last one is Williams. And this is a PAGA case, the Private Attorney General Act case. And in this case, it's what information a plaintiff in a PAGA Act is entitled to get in discovery. Things like names and contact information of all the other employees, or do they have to show good cause to get that? So this is going to be important because those of you who have been involved in these PAGA claims know that they're coming more and more often, and they're very expensive, and they're very difficult to fight. And with that, I will turn it back over to Linda.
And I'm going to invite Julie to jump on in.
Okay, great. I was just going to say, well, maybe Linda's going to get the question and answer.
Nope, it's all you.
Anyways, that was a great presentation, ladies. That, I know there's a lot to cover, and I'm sure there's more to come, but thank you so much for making it clear and helping us kind of navigate all of this. We are now going to allow the last few minutes here to take questions, and I'm sure, I'm looking at the ticker here, a lot of people are sending in some questions. How you do that is you type your question in over on the dashboard under the questions section and then hit return, and I will read those aloud for Marla and Linda to answer. And I'm going to start right away with one from Lori, and it has to do with more specifically the lunch hour breaks. And she wants to know, is it a state mandate that hourly employees take a lunch after 5 hours unless waived for a
not working fewer than 6 hours and signs a mutual, waiver, things like that. The rule actually says they have to start their lunch before the end of their 5th hour. So if somebody's working 8 to 5, technically that means by 12:59 they have to start their lunch. And it has to be a minimum of 30 minutes. You can require longer if you want to. I have one client that's wrote a handbook for that wants everyone to take an hour so they're there until 5, but it's a minimum of 30 minutes, and if they are not fully relieved of duty or not provided that or not provided in a timely manner, they're going to be subject to the penalty.
Okay.
And I would just add that this is not a new law. We had some recent case law a year or two ago providing more interpretation on that, but that's not new.
Okay. All right. Great. Thank you. Alma has a question. In regards to the minimum wage for Los Angeles, does it also refer to employees who are telecommuters and live in LA?
Well, time will tell, right? That's going to be the question, because we talked about this when this went into effect a little bit ago. We were talking about the LA law. How they're defining it is if the employee works in the city of Los Angeles for 2 hours in any given week, that makes them subject to the law. So yeah, you have to ask, what if I'm an Orange County employer, but I have an employee who lives in the city of Los Angeles, and I allow that person to telecommute from home 1 day a week? I think that you're subject to that for that day.
And I would agree with Linda, and err on the side of caution there. Hopefully we'll get some clarification, because the law is new. We'll get some clarification, but until we do, it's best to err on the side of failed to pay minimum wage, and then you have the liquidated damages, which is double that amount that you failed to pay.
Right, and the waiting time penalties and everything else. You don't want to be the test case, would be my suggestion.
Right, right. And Doris has another follow-on question with that. If you're an employer with 26 or more employees statewide, but only 10 of your employees work in LA, do you still need to pay the Los Angeles employees at the higher rate? I think she means the non-Los Angeles employees.
Yeah, that's an interesting question. I don't know without looking that up. Doris, what I would say, I think it is 26 or more employees in the city of Los Angeles, but what I would say to be certain is go to the link that I put in there. It's wagesla.lacity.org, and then there's a section for employers. I would go and specifically look at who's covered and just double check that, but I'm pretty sure it's 26 or more employees working in the city of Los Angeles, but I'm not positive.
Okay, great. Did you have anything to add, Marla?
No, I'd have to look it up as well. My recollection is the same as Linda's, but double check.
Okay. Alexandria has a question on the LA ban the box.
That doesn't mean a lot. We're of that age. Recollection.
Does the LA ban the box apply to drivers?
Does that apply what?
To drivers transporting hazardous materials?
You know, there are some exceptions, and I should have pointed that out, so thank you for that question. There are some exceptions. I did not make a note of them in my notes, but there are some exceptions where you can ask prior to, during the process. I don't know something like that. So yeah, so if you have a specific issue that is really critical to you, make sure you go and look, because there were like 3 or 4 exceptions to that, which I should have pointed out.
Okay. Yeah, I would agree with that. There are exceptions, and generally DOT, Department of Transportation jobs, or peace officer jobs. There are always exceptions to those. So you just need to pull the law or call one of us, and we can pull it for you and tell us the specific position that you're looking at.
Great. Chelsea has a question about marijuana right now, and do they need to specifically add that into the handbooks when discussing what is prohibited while working?
Well,
there's no oh, sorry, go ahead.
No, that's okay. Go ahead, Marla.
I was going to say, remember, there's no legal requirement to have a handbook. So you have no legal requirement in your handbook to put anything. We recommend you set forth the law, because the handbook is a tool for the people who are enforcing your policies as much as it is communication to the employees of what to expect and what's expected of them. Because you want to know, what am I supposed to enforce? So, for example, you have your equal employment opportunity laws stated in your handbook, because that's a law and you want everybody to know what it is. So are you required to by law? No. Should you? Yes. You should always effectively communicate with your employees. This is what's expected of you. By the way, you're expected not to come to work after smoking marijuana, ingesting marijuana, or using marijuana in any way, because I don't know what other ways they have, but I'm sure there are others, if that's the case.
Yeah, and I'll say, in our handbook, we used to have a big call out, bold letters about medical marijuana, so we had to change it going forward to just be marijuana in general. Very extensive drug policy in our handbook, and so that's just one section of it, but we called it out because, like Marla said, we get that phone call all the time. It has been up until now things like, my employee appears to be under the influence, but he said, yeah, he is, because I have a medical marijuana card. What do I do? And a lot of employees, like Marla said, think because it's okay in California that it's okay for them to be under the influence, and it's not. It's still against federal law, and you have the right to have a marijuana-free workplace if that's what you want. So I think it's better to be that specific, mostly because this is new territory. A couple years from now, it's probably going to be a non-issue, but right now, I would definitely call it out separately.
Okay, good. Thank you. And Susan, I'm glad you asked this question, because I have the same question. She has 2 single restrooms side by side, one for men and one for women. Are you now saying that we have to have both bathrooms listed as all gender?
That's exactly what I'm saying. Yep. I have a client, this is a very similar situation. They're literally like one to the right, one to the left. They have them marked men and women. And I just told them, buy your new signs, because you can't do that anymore.
Wow. Okay. I don't like that idea at all. But I don't want to share a bathroom with a man. Okay.
Well,
really, as long as there's more of them, I'm in. I don't care. I'm tired of standing in line.
That's a good point. Quick question on LA sick pay. How can I calculate sick pay for construction workers that work in a city of LA job? If I provide full 24 hours every July 1st, their office is based in Orange. So how does it work when you're calculating things like sick pay?
Well, you still have the ability to do the accrual. So there they have a higher benefit. You know, California-wide, you can restrict the usage to 24 hours. So one of the reasons we always we recommend to our clients don't use the accrual if they're full-time in particular is because, you know, they're going to continue to accrue. You have to allow it to roll over up to 48 hours. So an employee has a paycheck stub that says, I've got 48 hours accrued and you're telling me I can't use it. And I think that's really confusing. The good news about the LA paid sick leave is the same thing. You have to allow it to accrue, but you can cap the usage at 48 hours. So you can do it one of two ways, I guess, is the answer. You can go ahead and do the accrual, but you just have to allow it to accrue and allow them to use up to that 48 hours, or you could front load 48 hours for them instead of front loading the 24 hours. So that you have a few options there. Whichever you think, and really to me it comes down to a math problem. The break even for California for the 24, I think if you work 720, I think it was 720 hours or more in a year, something like that, then it's a break even. So I said, if I know my employee is going to work at least 720 hours, it makes more sense to me to front load it than to accrue it and have the additional issues that come with accrual. So, you know, this presumably would be twice that. So if they're working, you know, 7 or 8 months out of the year, it's going to be a moot point. So whichever is easier, set it up as accrual, 1 hour paid sick leave for every 30 hours worked, or go ahead and just front load the full 48. The good news also, if you keep it separate from vacation, if, you know, this is all bets are off if it's PTO, it's a different rule, but if you keep it separate from your vacation, then it doesn't have to be paid out. So you run the risk that someone's going to use it right away, but if they leave the company, it's not an accrued liability on the books. You don't have to pay it out to them.
Okay, great. Well, we have right now, I know you have lots of questions, and of course in the handout are emails for both Marla and for Linda. Linda, I'm hoping you can talk a little bit about what we're going to plan for next month in lieu of our webinar.
Exactly. I'd love to. I'm really excited about this. Some of you were in attendance when we did a seminar last fall where we had a gentleman from Zenith Insurance and an assistant district attorney come and talk about workers' comp fraud. This is sort of our follow-up to that. We're having a special presenter, Diana Henderson, with the Henderson Group. Marla and I have used her with our clients before, and it's really a different take that most employers will not have an opportunity to see, because Diana's background is actually as a claims adjuster. She now does training for the state workers and other insurance agencies on how to manage claims. We bring her into our clients when there's a sticky situation with workers' comp, because that's what she does. She'll come in, either you can outsource your workers' comp claims management to her, or you can just say, hey, can you help us with this one claim? So we're going to have her talk about how to manage the workers' comp claims. So let's say it's not fraudulent, you have it, but oh my gosh, you're looking at this huge reserve that, you know, the carrier set up, or you can't get the carrier to investigate it, or whatever. Like, what are the things that, you know, she knows, those sneaky claims adjuster tricks that she can share with us that will help manage those claims and keep then the premium costs down and keep your XMOD down. Plus, there's a new method of calculating experience modification factors that went into effect, so she's going to talk about that, and then Marla's going to talk about 132A claims. All of this, which is just risk to employers and a high cost to employers. So this is going to be an in-person seminar. It's going to be held at Marla's office. The link right there is to register. It's free. We're just doing it, you know, in person, and it's going to be, space is going to be limited to the first 50 people. So hopefully people will get online and register.
You know, reduce your XMOD costs. So that will do it for, we are going to be taking a break in February and returning again in March, and you'll receive communications on our next webinar. So we appreciate your time today and look forward to providing you with more useful information in the future. Thank you very much.